A dog attack can shatter lives in seconds, leaving the victim financially and emotionally scarred and the dog's owner facing devastating legal and financial consequences. New York's highest court just made it much easier for anyone who is injured by a dog to sue, win, and recover. My name is Phil Rizzuto of the Rizzuto Injury Firm. We represent individuals who are injured throughout all 5 boroughs of New York City, all over Long Island, Westchester, and beyond. In this video, I'm going to walk you through the historic case of Flanders versus Goodfellow and explain to you how the dog bite law in New York has changed forever. Before the Flanders case was decided, anyone who was injured as a result of a dog attack had to prove that the dog had vicious propensities and that the owner of the dog knew about it. In fact, we used to say that every dog in the state of New York was entitled to 1 free bite. But vicious propensity does not only mean biting or attacking. It could be growling, it could be sneering, it could be lunging. If the victim is able to show that the dog had vicious propensities and the owner knew about it, they were entitled to what's called strict liability. Means it's an automatic win. There are no defenses to a strict liability claim. However, before Flanders, if you were unable to prove that the dog had vicious propensities and the owner knew about it, you lose. You get nothing. So what the Court of Appeals did in Flanders, they stated that even if you can't prove that the dog had vicious propensities, if you can show that the owner of the dog was negligent, meaning they failed to use reasonable care in controlling the pet, then you could bring a claim. Flanders was a postal carrier who went to the door to deliver a package. The owner opened the door and the dog got loose and attacked Flanders. The court found there was an issue of fact as to whether or not the dog had vicious propensities and that the owner knew about it, but stated that Flanders could bring a lawsuit based upon the owner's negligence in failing to control the dog. So what the court held in Flanders is where an animal causes injury and the owner fails to use reasonable care in controlling the animal, they can be held liable, meaning responsible, under the theory of ordinary negligence. So what that means is even if the dog never showed signs of aggression before, the owner could still be held responsible. In every personal injury case, we need to meet 3 prongs in order to be successful. The first prong is there needs to be liability. Somebody has to be negligent in causing injuries to someone else. The second prong is there needs to be an injury caused by the neglect. The third prong is there needs to be a deep pocket that has the ability to pay for the injuries caused by the neglect. That is usually an insurance company. If you have an injury and you have neglect, but there is no insurance coverage, it may be very difficult to recover for the damages caused by the attack. Now, the Flanders case just made the first prong much easier to prove because you can still bring a claim for strict liability if you can show the dog had vicious propensities and the owner knew about it. But if you were unable to establish a dog had vicious propensities prior to attacking you, you can still bring a claim like Flanders did based upon ordinary negligence. Now, when it comes to the injury prong, being scared is not enough. If you are attacked by a dog but do not sustain a serious injury, but you are now terrified of dogs for the rest of your life, that is not enough to bring a claim. If you are attacked by a dog and you have medical documentation to show that you sustained a physical injury, you can bring a claim. If you are also terrified of dogs with the physical injury and you have medical documentation to establish it, you are having trouble sleeping, that you don't want to go near dogs, and there is medical documentation to support it, you can also bring a claim for psychological injuries, and that could be a very, very significant claim. Finally, there needs to be a deep pocket that has the ability to pay for the injuries caused by the neglect, and that is usually an insurance company. But some insurance policy will exclude attacks by certain dogs, such as pit bulls or Doberman. And if you are attacked by someone who has a dog and they don't own a home and they have no insurance coverage whatsoever, then in order to recover, you have to get a judgment and you have to collect from that person individually. And the chances of doing that are very, very slim. Let me tell you about a case we recently settled for $485,000. The case was very similar to Flanders. My client was an Amazon driver making a delivery to someone's home. When the dog's owner opened the door, the dog got out and attacked my client and took a big chunk out of her leg. As a result, my client had to undergo extensive treatment. Not only did she have to get stitches, she had to get rabies vaccines, debridements, skin grafting, and went a couple of years with continuous treatment as a result of this attack. Her injuries were severe and permanent, and they only had an insurance policy of $500,000. In order to resolve the case without any further litigation, having to appear for a deposition, and incurring future expenses for litigating the case, my client agreed to accept the offer of $485,000 to resolve the case in its entirety. In that case, we had all three prongs. We had liability, we had injuries caused by the neglect, and we had insurance coverage that was able to pay for the damages caused by the dog. So what does it mean for you as a dog owner? If you own a dog and it attacks somebody and you are found responsible, if the injuries exceed your insurance coverage, a judgment can be entered for you in excess of the insurance amount, and you will be responsible to pay. And if you ever go to sell your house, you will have to pay that judgment that accrues interest at a rate of 9% per year before you can sell your house. If you don't own a house, they can garnish your bank account and they can get the money from your bank account, or they can garnish your wages until the judgment is paid off. So what you need to do as a dog owner is be responsible. If you're walking your dog, make sure the dog is on a leash. Make sure you're paying attention. Make sure the dog is secure in your house and doesn't get out of the yard, because the old law establishing that the dog had vicious propensities is no more. All a victim has to do is show you were negligent. Show you failed to use reasonable care under the circumstances then and there existing, and you will be found responsible. If you or a loved one have been injured as a result of a dog attack, ring Rizzuto at 855-RIZZUTO. We can help. If you found this video helpful, subscribe to the channel, follow for more, and I will see you next time.